Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
Namaste दोस्तों, welcome back to Ganga Education. Today, we're breaking down a landmark contract law case that is absolutely guaranteed to appear in your upcoming LLB and Judiciary exams. We're talking about Tinn v. Hoffman Co. from 1873. I'm going to explain this case in a way that you can revise it in just 5 minutes before your exam. We'll cut out all the unnecessary noise and focus strictly on what actually fetches you marks. So let's dive right in. Here's a quick look at our syllabus-mapped agenda. We're covering the intro, the facts, the legal issues, the court's reasoning, the final judgment, and finally, some bonus MCQs to test your recall. All right, starting with the case intro, exam ke liye ye case bahut important hai, so let's get those basic credentials down first. So this 1873 case was heard in the UK Court of Appeal in Chancery. You'll want to note down the citation, LR 8 CH App 308. The bench was led by Lord Selborne LC, along with Lord Hatherley LC and Sir George Jessel MR. Listen, whenever you're writing a mains answer on the doctrine of consideration, quoting this specific bench is going to immediately show the examiner that your concepts are crystal clear. Moving on to the facts of the case. Ab aate hain facts par, and honestly, it's easiest to look at this as a simple chronological story involving 3 people, a creditor, a debtor, and a guarantor. Let's trace the timeline. Day 1, a guy named Alfred owes a debt to our plaintiff, Tinn, but Alfred can't pay. So, on day 2, the defendant, Hoffman Co., steps in and gives Tinn a guarantee. They essentially say, hey, if Alfred fails to pay, we'll clear the debt. In exchange, Tinn agrees to forbear from suing Alfred. Basically, he promises not to take legal action against him. But then, day 3 rolls around, and guess what? Hoffman Co. also fail to pay. Naturally, Tinn sues Hoffman Co. to recover his money. Sounds like a straightforward breach of promise, right? But legally, it's an absolute minefield. Which brings us to the legal issues and arguments. Let's look at the legal provisions and see how this simple conflict actually turns into a major question of law. Now, ye concept exam mein direct aata hai. The doctrine of consideration is the absolute bedrock of a valid contract. For any agreement to be enforceable by law, there has to be a quid pro quo. Something in return. It has to involve either a legal benefit to the promisor or a legal detriment to the promisee. Without it, well, a promise is literally just a bare promise and it's totally unenforceable in court. Ye sections exam mein frequently पूछे जाते हैं. You definitely want to cite the UK Contract Act 1872, Section 111, which defines a contract as an agreement enforceable by law. More importantly, cite the Mercantile Law Act 1858 of the UK, Section 1, which makes it crystal clear that an agreement without consideration is not enforceable. Now, a quick exam tip on how we view this in India today. Proving the existence of such a guarantee actually requires direct evidence under the Indian Evidence Act, like a written document. Circumstantial evidence just doesn't cut it for commercial contract terms. But in our case today, they weren't arguing about whether a promise was made, they were arguing if it was legally valid. So the whole thing boiled down to 2 super specific legal questions. First, was Hoffman Co.'s promise to pay Alfred's debt sufficient consideration for Tinn's promise not to sue Alfred? And second, based on that answer, was the guarantee actually enforceable? What's really fascinating here is how the 2 sides totally clashed over the word benefit. Tinn argued that Hoffman Co.'s guarantee was absolutely valid consideration because it secured the debt's payment, a clear benefit to him. On the flip side, Hoffman Co. brought up a brilliant technicality. They argued that promising to pay a third party's debt provides no direct, fresh benefit to Tinn, meaning it's simply not sufficient consideration. All right, let's look at the court's reasoning. Court ne yahan ek important principle diya, and this is literally the most critical part for your exam analysis. Let's see how the bench broke this down. You need to memorize this exact quote for your mains paper. A promise to pay a debt of a third party is not consideration for a promise by the creditor to forbear from suing the debtor. Ye concept yaad rakhna guys, because it perfectly defines the strict boundaries of privity and consideration back in 19th century English law. The majority opinion, led by Lord Selborne LC, brilliantly pointed out that the guarantee was just a promise to pay a third party's debt. In the eyes of the law back then, this just didn't give Tinn any fresh, legally recognizable benefit. Because there was no direct benefit or detriment moving specifically between these 2 parties, Tinn's promise to not sue lacked valid consideration. It was completely empty. And the court didn't just pull this out of thin air. They backed it up with heavy historical precedents. They cited Diver to Pearson from 1807 for the exact rule on third-party debts. They brought in Combe v. Combe from 1824, stating guarantees need a benefit or detriment. And of course, the legendary Stilk v. Myrick from 1809, cementing the rigid need for fresh consideration. Dropping these case names in your exam will absolutely fetch you extra marks. Okay, moving to the judgment and principles. Let's see what the final verdict was and what core doctrines we can extract from this explainer. E case, हमें ये principle देता है. The final holding ruled that Hoffman & Co.'s guarantee was dismissed. It was strictly not enforceable. Why? Simply because it lacked valid consideration. Poor Tinn was left without any legal remedy against the guarantor just because that foundational requirement of a contract was missing. Now let's put on our professor hats for a quick critical analysis. This judgment had massive legal significance, cementing strict rules around privity and consideration. But here's the catch. It is heavily criticized today. Why? Because it completely ignores modern commercial realities. In today's business world, third-party guarantees are literally everywhere. Still, the legacy of this case is huge. It was cited in later cases like Scottson v. Pegg and Gates v. Gates, which just goes to show how courts constantly struggle when applying rigid historical laws to evolving real-world business practices. Finally, we're at our bonus MCQs and exam practice. अगर आपको ऐसी ही case law simplified चाहिए, subscribe ज़रूर करें. Now let's test your active recall. Here's your first MCQ. Under Tinn v. Hoffman, is a promise to pay a third party's debt valid consideration? Option A, yes, always. Option B, no, it lacks fresh benefit. Option C, only if in writing. Or option D, yes, if the debtor agrees. Pause the explainer right here. Think back to that maxim we just discussed and drop your answer in the comments. Also, as a quick conceptual thought, if consideration must move from the promisee, does a third-party guarantee satisfy this? Under this old strict rule, the answer is generally no. Keep that in mind. And for your Judiciary or CLAT PG mains practice, take a screenshot of this open-ended question right now. Critically analyze the doctrine of consideration in light of Tinn v. Hoffman. Does it overly restrict modern commercial realities? I want you to think deeply about the critical analysis we just covered, balance that strict legal rule against practical business needs, and try drafting a solid 15-mark answer. That wraps up our quick deep dive into Tinn v. Hoffman. Like, share, or Ganga Education को subscribe करें. यहाँ law समझाया जाता है. Keep revising, keep practicing those answers, and I'll see you in the next explainer.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.